are here.
Petition Kafi and another versus Aziz Iyari and Al-Hassan another and Ishaku. It therefore follows that because of action in this petition, which is rooted in the nomination or sponsor of the correspondence of a pre-election matter, being a pre-election matter, the petitioner herein has no local standing to challenge or question such nomination or sponsorship of the correspondence by the second respondent. Thus, in the People's Democratic Party, PDP, and the Independent National Electoral Commission and others, and reported the decision of the Supreme Court, delivered on 26th day of May 2022 in SC of CV of 501 of 2022. I have the matter has been reported, but I have not been able to avail myself of the report. That at the Supreme Court said at the 7-1 at follows, exact one like 116 there as follows. Fourth, the provision does not make the filing of pre-election matters by political parties an all-timers affair. It is not the purpose of the provision that the floodgate of pre-election litigation be open to political parties who will hide under it, challenge the actions or inactions of rival political parties under the guise of challenging the decision or activities of any. The application of Section 285, Section 14C of the Constitution does not extend to a political party poaching into the affairs of another. The position of the law has always been that no political party can challenge the nomination of the candidate of another political party, no matter how pained or disgruntled the political party is with the way and manner another political party is. It is clear, therefore, that a political party such as the petitioner sharing only has the local standing to file a pre-election matter when the situation affects it or its candidate by virtue of Section 285, Section 14C of the 1999 Constitution. That being so, as in the instant petition, where the grounds of the petition is rooted on the nomination or sponsorship of the candidate of another political party, this petitioner will have no local the third and fourth respondent. By the second respondent applicant, the petition is incompetent for lack of local standing when the petition disputes the action. It is also likely to be struck out for being incompetent.
Well, we are going to
the second respondent applicant also contended
exactly
that the petition is not properly
what they are going to
the candidate sponsored by the petitioner has not been joined as co-petitioner in the petition. The short answer to that is that Section 133, Section 1D of the Electoral Act 2022 entitles the petition as a political party to institute an election petition. The applicant has not referred us to any provision of the Electoral Act or any authority that mandates the political party to file an election petition only when its candidate has been joined as a co-petitioner. It is true that it is proper for the candidate of the party to be so joined, but there is no law that compels the political party join its candidates in the petition. After all, the purpose of such joinder is so that the candidate can be bound by any judgment or order of the court or tribunal. Any non-joinder will not invalidate the petition. This is particularly so when Section 133 of Section 1 of the Electoral Act stipulates as follows. An election petition may be presented by one or more of the following persons: A, a candidate in an election, or B, a political party which participated in the election. By the use of the disjunctive word "or," it means that an election petition may be filed by the candidate alone, or the political party alone, or both of them. The objection on this ground is also disconcerting. By another motion filed on the 15th of May 2023, the fifth respondent, thus Kabir Masari, prayed this court to grant him the following reliefs. 1. An order of divisional court dismissing this petition in its entirety for want of jurisdiction. 2. An order striking out the name of the fifth respondent applicant from this petition for non-disclosure of any reasonable course of action against him. And first, other orders are this honorable court may deem fit to make in the circumstances. The grounds for the applications have been cases have also considered the submissions of counsel. Now, Section 133. Section 133 of the Electoral of defines persons who are necessary parties in an election petition. Generally, necessary respondents in an election petition are the persons whose election or return is complained of and the electoral body that conducted the election. This Section 133, subsection 2 and 3 of the Electoral Act 2022. Those are what are termed statutory respondents. It should be remembered that election petitions are sui generis. As sui generis and is considered strictly regulated by statute. That's why a person does not fall within the category of statutory respondent. They are not registered parties in election petition. See the cases of Agbere and Mimra, Buhari and Yusuf, APC and PDP. That's in Waziri versus Gaidam. The Supreme Court held a court. From the above, I have no difficulty in going along with the submission of the Statutory Council for the respondent. The Section 137, 2 and 3 of the Electoral 2020 has no room for the joinder of the state respondent who neither won the election nor performed any role as electoral officer or agent of the third respondent in the election petition, challenging the result of such an election. And even no relief was claimed against the said fifth respondent, and indeed, he had nothing to gain or lose in the petition of the close of court. Indeed, a holistic reading of the facts of this petition does not disclose any complaint against the fifth respondent. The only fact that relates to the fifth respondent relevant to the petition is the act of withdrawal of his candidacy as the running mate of the third respondent. That is an act that occurred within the pre-election period, therefore cannot amount to any act done by the fifth respondent at the election. It cannot therefore ground any complaint by the petitioner against the fifth respondent in an election petition. It may be relevant in a pre-election matter, but not in an election petition. It is therefore my finding that there is no any claim on the fifth respondent. Otherwise, the relief sought in the petition will not in any way affect the fifth respondent, as he did not participate in the petition either as a candidate or agent of the second respondent, and no declaration was made in his favor as the first respondent. In that respect, I hold that the objection of the fifth respondent in this round
Yes,
has merit. Particularly
For
after
YouTube.
that the name of the fifth respondent
you know, say this election, petition they go on.
petition number 4.
So they cover them.
I will now go to the
I'll call you,
main petition itself. So after the pre-hearing session, hearing on the petition opened and closed on the 21st of June 2023, the petitioner called one witness and closed his case. None of the respondents called any witness, but tendered some documents from the bar, and the petition was adjourned by docket or written addresses. Parties then filed and submitted addresses as directed by this court, and same were adopted on the 14th of July 2023. The matter was then adjourned for judgment. The first respondent's written address was filed on the 30th of June 2023. Therein 4 issues were raised for determination as follows. 1. Whether considering the facts of the petition and evidence laid thereon, the petitioner has the locus standi to question the nomination of the first respondent as a ground of challenging the qualification and stand of the third respondent as the winner of the presidential election 26 February 2023. 2. Whether having regard to the facts pleaded and evidence laid thereon, vis-a-vis the provision of Section 1 at 4 subsection 3 of the Electoral Act 2022, and the issue of validity of the nomination of the first respondent as the vice president candidate or second respondent, is validly raised as a ground before this honorable court, question or challenge the qualification and return of the third respondent as the winner of the presidential election of 25th February 2023. Number 3, If the answer to note 2 is in the affirmative, whether having regard to the facts pleaded, the nomination of the first respondent as the vice president candidate of the second respondent is void, as to render the third respondent not qualified to contest the president election of 26 February 2023. Or whether considering the relief sought as per the petition approves no utilitarian benefit to the petitioner, petition not an abuse of court process. Well, to save time, all the other respondents filed briefs and raised issues. These issues have been discussed in this judgment, including the issues raised by the petitioner.
While they were doing the court case, these people
Now, it
did
is
do
apparent
last.
from the averments in the petition, the oral and documentary evidence, and the submissions of counsel that this petition is grounded on the disqualification of the third respondent for having contested the presidential election of 26 February 2023. This is evident in paragraph 15 of the petition, wherein the petitioner pleaded that I read it earlier. This is further explained as emanating from the non-qualification of the first respondent who have contested the election as the vice president candidate of the second respondent. It is specifically pleaded in paragraph 17 of the petition as follows. Your petitioner states that the fourth respondent was not qualified to contest, jointly contest with the third respondent for the presidential election held on 26 February 2023, having been purportedly nominated by the second respondent as its candidate for more than one office. The specific reasons for questioning the qualification of third respondent have been pleaded in paragraphs 1 and 2 of the petition as follows. Those paragraphs have been reproduced. If you get the judgment, you will see it there. So a combined reading of paragraphs 15, 16, and 17 of the petition, coupled with the particular thereof, show clearly that the petition is premised on non-qualification of the first respondent. I find it necessary to state that the grounds for questioning the return at an election are stipulated in section 135, section 1 of the Electoral Act, that has been produced earlier. For the purpose of this petition, it is the ground stipulated in section 134(1)(a) that is relevant. In other words, the election of the third and fourth respondent as president and vice president is questioned on the ground that they are not qualified to have contested the state presidential election. I consider paragraphs 18, 19, 20, 21, 22, 23, 24, 26, and 28 as relevant for the termination of the petition. Which paragraphs have been introduced in this judgment? In response, the first respondent, Judge INEC, filed a reply to the petition where it was averred in paragraphs 14, 15, and 16 of the first respondent reply to the petition as follows, which has also been produced. Second respondent also filed a second respondent reply to the petition, also made their own averments in paragraph 16, 17, 18, 19, 20, 21, 22, 23, 24, 25, 26, and 25, 29, which have been produced herein. So from the totality of the pleadings in the petition and the replies of the respondent, what appears from the complaint of the petitioner is that the fourth respondent, while still a candidate of the second respondent for Borno's Central Electoral District, was nominated and did accept to be the vice president candidate of the second respondent. That this act violated the provision of Section 35 of the Electoral Act 2022 as it amounted to his double nomination. That in the circumstances, his nomination as an associate of the second respondent for the presidential election is void. And the result is that the third respondent was disqualified from contesting the election because he did not have a validly nominated running mate at the time of the election. A petitioner relied on Section 131 and 142(1) of the 1999 Constitution for his postulation. Section 131 and 142 sub 1 of the Constitution of the Federal Republic of Nigeria as amended stipulate as follows. A person shall be qualified for election to the office of president if A. He is a citizen of Nigeria by birth, B. He has attained the age of 40 years, B. He is a member of a political party and is sponsored by that political party, and D. He has been educated up to at least full certificate level or its equivalent. 142(1). In any election to which the foregoing provision of this part of this chapter relate, a candidate for an election to the office of president shall not be deemed to be validly nominated unless he nominates another candidate as his associate from the same political party or his running mate for the office of president, who is to occupy the office of vice president, and that candidate shall be deemed to have been duly elected to the office of vice president if the candidate for election to the office of president who nominated him as such an associate is duly elected as president in accordance with the provision aforesaid. The general principles of interpretation of the Constitution, which is the supreme law of the land, is that mere technical rules of interpretation of statutes are to some extent be avoided in a way as not to defeat the principles of government. That's why the words used are clear and unambiguous. A literal interpretation should be applied. In the interpretation, therefore, the clauses of the Constitution are to be accorded holistic interpretation so as to avoid ambiguity and arrive at the true intention of the legislature. The court must limit itself to the words used in the Constitution without resort to any external aid or materials. In the cases of Sani and President Federal of Nigeria, Hamadi and Ani, and Agi and PDP and others. Thus, in Wike Ezo Mweson, Honorable Dr. Puku, Admiral Peterside, and others, the Supreme Court observed that the principle of conception of the Constitution to the effect that the Constitution is a living document, not just a statute, providing a framework for the governance of the country, not only for the present, but for generations yet unborn. It was held that in construing the Constitution, undue regard must not be paid to merely technical rules, because in doing so, the objects of the Constitution as well as the intention of the framers of the Constitution will be frustrated. Courts have always been encouraged to adopt a broad and liberal spirit in interpreting the provisions of the Constitution, while constantly bearing in mind the object which such provisions were made staff close to court. That being so, while the Constitution has stipulated the qualifications to be attained by a person contesting or seeking to contest for any elective office created by the Constitution, the courts cannot create or import into the Constitution any other qualifying or disqualifying factor. This has been the position of the Supreme Court and dutifully followed by this Court. It has therefore been held that qualification or disqualification of candidates to contest the election is exclusively determined within the context or scope of the Constitution, and that nothing can be added to it. In other words, the Constitution being the ground norm, superior to any other law, including the Electoral Act. Therefore, where the Constitution has qualified a person or candidate to contest an election, no other law except the Constitution itself can disqualify him. The petitioner, in this case, has premised his complaint of non-qualification or disqualification of the third and fourth respondents as the president and vice presidential candidates of the second respondent on the issue of invalid nomination of the fourth respondent. The fourth respondent, while still the senatorial candidate of the second respondent for the Borno Central Senatorial District, allows himself to be nominated as the vice presidential candidate of the second respondent for the same election. Rulings earlier delivered on the motions and prelude objections, we had ruled that the petition grounded solely on the issue of invalid nomination or improper nomination is not a cognizable ground for disqualification under the Constitution. In other words, the claim in the petition that the third respondent was not qualified to contest the presidential election because he nominated an associate whose nomination was invalid, does not flow from any ground of disqualification of the candidate to the office of president as stipulated in section 131 and 137 of the 1999 Constitution. In the cases of Balewa and Mwazu and Faleke and Ainik Azub versus Giora, and the Shinkafi versus Yari, the Supreme Court held that the Supreme Court has listed in section 182, section 182 very exhaustively all the issues that can qualify a person from contesting the office of governor of a state. From the record of this court, the facts have not disclosed any evidence to show that the first respondent was not qualified to contest elections into the office of governor of Zamfara State. It is my view that once a candidate sponsored by his political party has satisfied the provisions set out in section 177 of the Constitution and is not qualified under section 182 of section 1 thereof, he is qualified to stand election to the office of governor of the state. No other law can qualify him. This authority can apply mutabis to section 131 and 137 of the Electoral Act. It has not been contended by the petitioner that either the third or fourth respondent is trammeled by the provisions of section 131 or 137 of the 1999 Constitution. The complaint of the petitioner rooted on nomination and suspension of third and fourth respondent will find accommodation in a pre-election dispute which the petitioner cannot even pursue, not being a member of the second respondent. This section 84, section 14 of the Electoral Act 2022 and 285, 14 of the Constitution. While I'm tempted to put an end to this petition at this stage, but realizing that this court is not the final court on the matter, I'm concerned to look at the merits of the petition. As pointed out earlier in the course of this the complaint of
Nigeria
this petition is that the
power holding company refused to give us light. Refused to give many Nigerians light.
This is because
watch this election petition judgment. They know exactly what they are doing. Everyone is running on generator. In fact, my entire street, they are running on generation currently.
As stated earlier, the petition contended that
my entire street are running on generator currently. Generator that place, generator my house, generator the next compound, everybody is running on generator. They refuse to give us light. And we usually have constant light. But today they say no, they are not going to give us light. And again, why did they decide to televise this? They didn't televise it or why they were presenting things, why they were doing the judgment. No. They decided to televise the end game. Well, so far so good. Whatever the judgment has been, they have been passing since, has been in favor of APC. Shetima, when they said that he wasn't qualified to be running for vice president alongside Tinubu, if you listen closely, they said it's not that is qualified. So far so good, he has been in favor of APC. So let's still be watching though.
After the withdrawal of the fifth respondent, the respondent considered that the first respondent was ab initio a central candidate of second respondent of Borno Central District. However, on the 6th July 2022, the first respondent via a letter dated the same day notified his political party, that second respondent, of his withdrawal from the central candidate. That upon receipt of the first respondent letter, the second respondent immediately notified.
Why they allow this man?
And which notification letter was received on the 13th July 2022. That the same letter also notified the first respondent of his intention to conduct a fresh primary election for the replacement of the first respondent following his withdrawal as a central candidate. That it was until 14th July 2022.
So far so good. Peter Obi is not in court. Atiku is not in court. Tinubu is not even around. Tinubu is not even in Nigeria. He's in India doing Nigeria business. But Tinubu is not in court. Atiku is not in court. It's not like advisable for them not to be in court. You know, it's advisable for them to just remain there, to remain in their private residence, not to be in court. You they see this chairman, they see. This one here, is sleeping. Shetima, I know the sleep. Oh, he's a very strong man. Oh. But why they go put Shetima sit down for close to Labour Party chairman? See, Festus Kiyamo here, the aviation minister.
For a judgment to constitute issue a statement, the conditions are as earlier stated in the rulings. So the three elements must be present and coexist for a plea of estoppel parental data to apply. In the cases of Ito and Epe and others, Oshoboja versus Amita and others, and Alexander and others versus Lone Star Drilling Company Limited, all citations apply. It is obvious that the judgment sought to be relied on for the plea of estoppel is that of the Supreme Court, the highest and final court in this country. There is no doubt that the decision was final, and the issue that was done by the Supreme Court is the same as in the present petition, with whether before the respondent breached Section 35 of the Electoral Act by allowing himself to be nominated in more than one constituency. The petitioner has, however, argued that the issue decided by the Supreme Court was merely on the local candidate of the PDP to question the nomination of the respondent, the candidate of APC, different political party. That may well be so, but it is clear from the judgment that Exhibit S1 that the Supreme Court pronounced on the substantive issue of double nomination. So, Joro JSC, who delivered the lead judgment, declined to exercise the powers of the Supreme Court under Section 22 of the Supreme Court Act to pronounce on the merit of the case. The other laws of the Supreme Court proceeded so. It is settled law that a contributory or concurrent judgment has equal weight as the lead judgment. It is part of the lead judgment and therefore has the same force and binding effect. The mere fact that a concurring or contributory judgment contains what is not in the lead judgment will not whittle down binding effect. That's in Olu Erba and others versus Abdurrahim. My Lord Fabi JSC said, of course, a concurrent judgment has equal weight with or as a lead judgment. A concurrent judgment complements.
The problem I have with this live video is that why are they not showing the judge's face? Why are they not showing the judge's face? I do not know. And that guy said, Peter Obi, don't leave us. Don't leave his supporters. It's not advisable now. Atiku is not also there. Tinubu, of course, is doing Nigeria business. He's not also there. Not only Peter Obi. Kwakwaso is not even there as well. So many of them are not here. But just in case there is any form of rerun, Kwakwaso already has alliance with Tinubu. Kwakwaso already has alliance with Tinubu. Tinubu has already done his background work. But it is very, very hard. It is very, very unlikely for Tinubu not to win this case. Not because of credibility, because of how Nigeria be. It is very unlikely. So far, the judgment has been in favor of APC. So far. But they should be showing the judges' faces now. Show us the judges. There are about 5 judges. Show us their face. It doesn't mean anything. Nobody is clamoring for any form of fight. Even Labour Party released a statement yesterday. They say no fighting, no. But there's a massive protest going on now in Eagle Square. Serious massive protest. Massive protest. Not like a protest, but a peaceful one. A peaceful protest where people gather and talk.
Yanati Petrochemical Limited and EFCC then Ladi Jobi and others was Oguntayo and others, Petition Supply. It is no doubt that the judgment matter in PDP and INEC others is S1 was in respect of the alleged government nomination of the first respondent as the vice president candidate of the second respondent in the 25th February 2020 presidential election. That is the same issue raised in this petition, as grounding the disqualification of part and further respondent in this petition. Pronouncing on this issue in this case, in the conclusive judgment, my Lord Okoro JSC, who presided on the panel of the Supreme Court, held as follows: I quote, "There is no doubt that the first respondent was at the stage nominated as a candidate representing Borno Central District, but upon being muted, he would pair with the third respondent as vice presidential candidate or second respondent, All Progressive Congress, APC, in the 26th February 2023 general election. He withdrew his candidature for the Senate before taking up the position of vice presidential candidate. Documents in the record attest to this fact. These are APC 1, APC 2, which were made on the 6th and 10th of July 2022 respectively, those of court. After considering those documents, the Lordship concluded at page 7 of the concluded judgment that it is crystal clear that the two exhibits alluded to above, the first respondent did the needful by resigning his position of Senate candidate for Borno Central District on 6 July 2022, before being nominated by the third respondent to run alongside him as vice presidential candidate for Congress. My Lord Okoro went on to, after citing section 31 of the Electoral Act 2022, held at page 8 of his conclusive judgment at court. The above provision of the Electoral Act 2022 was duly complied with by the respondent. My well-considered opinion that as at the 6th of July 2022, having withdrawn nomination and personally served sent on the second respondent of the withdrawal of nomination of 6 July 2022, first respondent was no longer a candidate for the Borno Central District election, and his subsequent nomination as vice president candidate of the second respondent for the presidential election was not multiple nomination, as there was no longer a nomination for the first respondent since his withdrawal on the 6th of July 2022. Also cited the elaborate petition of worship against JSC. So I have endeavored to quote extensively the data of the laws of the Supreme Court in PDP and INEC Supra in order to show that the issue of double or even multiple nomination of the first respondent as the central candidate and vice presidential candidate of second respondent in the 26th February 2022 general election has been settled finality. The judgment in them, therefore binding on the parties this petition and in fact the entire world, including this court. Being the judgment of the final court of the land, or this land, in the Supreme Court, no person is permitted to again raise and litigate on it in any other action or proceeding. It is therefore settled and remains settled that this petition, which questions the qualification and seeks to disqualify the third and fourth respondent from contesting and occupying the seat of President and Vice President of Nigeria on ground of double or multiple nomination of the first respondent and Vice President candidate of the second respondent on ground of double or multiple nomination of first respondent has no substance. I only wish to add that Section 35 of the Electoral Act is targeted at the candidate and not the political party. That is why it uses the terms candidate and normally allows himself to be nominated by more than one political party or more than one constituency. That's to prove that a candidate normally allows himself to be so nominated, both the intent and actual act of nomination, that is, the mens rea and actual use of the act prohibited by proof, the stipulation in the section being a penal provision. In the instant case, neither the intent nor the fact of the first respondent who allows himself to be so nominated was established. That's why His Lordship of whom it gets on Petition Judgement, Exhibit X1, held as well as I court. By Section 31 of the Electoral Act, the first respondent, Shetima, was obliged to submit a notice of withdrawal in writing to his party, which he did, and then his party is to deliver that notice the Commission not later than 90 days to the election. In view of the above stated position of the law on this issue and the facts of this case, there exists no animus or display of intention by the first respondent to stand as the nominated candidate of the second respondent for the vice presidential position and also the senator representing Borno Central District in the general election of 26 February 2023. There cannot be any other interpretation in the circumstance unless there is clear intention to knowingly stand as a candidate for two elected posts in the same election cycle. Game JSC also contributed as follows. The manifest intention to relinquish the earlier nomination to pave way for the nomination of another person to replace him as the party's central candidate cannot be overlooked or disregarded. To simply isolate the assumed or purported short-lived coexistence of the two nominations for treatment as multiple nominations without regard to the obvious intention of the first respondent not to be the party's candidate in elections in two constituencies against the legislative intent of Section 35 of the Electoral Act 2022. The sequence of the occurrence of the event is not what determines the existence of multiple nominations. It is the intention, design, or purpose to hold two or more nominations as candidates for election that shows that the persons who are nominated knowingly did so. The second respondent did not intend that the first respondent would be its candidate for Borno Central election and his vice presidential candidate for the presidential election. The first respondent did not understand.
They don't show the video of the judge where they talk. They call the show sketch of the judge that is talking. Oh, Nigeria. They didn't show the video of the judge. They are showing the picture. The judge that is live talking, they couldn't show it. They are showing the picture. Show the face now. Nobody is using it to do anything now. Show the face now. Eba. Nigeria, oh God. Oh God. They are showing the sketch of the judge. They didn't show the face.
That the second respondent did not comply with Section 33 of the Electoral Act in the nomination of the first respondent as vice presidential candidate. That after the withdrawal of the first respondent, second respondent should have conducted a fresh primary election within 14 days for the purpose of nominating a new vice presidential candidate. Now, Section 33 of the Electoral Act stipulates that the political party shall not be allowed to change or substitute the candidate whose name has been submitted under Section 29 of this Act, except in the case of death or withdrawal by a candidate, provided that in the case of such withdrawal or death of a candidate, the political party affected shall, within 14 days of the occurrence of the event, hold a fresh primary election to produce and submit a fresh candidate commission for the election concerned. The interpretation of this provision does not cause any difficulty as to require
These are the judges.
Any technical construction. Therefore, a literal interpretation will suffice. It therefore means that where a political party has
These are the judges.
the name of a candidate pursuant to Section 29 of the Electoral Act, it cannot be allowed to substitute or change that candidate except in the event of death or withdrawal.
These are their names.
By the proviso thereto, the political party affected is enjoined to conduct a fresh primary election for the purpose of producing a new or fresh candidate to submit to the Electoral Commission. The grounds of the petitioner here is that the first respondent withdrew his nomination as vice presidential candidate of the second respondent, but the second respondent did not conduct another primary election for the purpose of producing a new vice presidential candidate within the 14 days prescribed by Section 30 of the Electoral Act. It should be remembered that by Section 142 subsection 1 of the 1999 Constitution, a presidential candidate for election to the office of president has the sole discretion, authority, or power of nominating his associate who shall run with him in the election as vice president. The choice or nomination of vice presidential candidate is not the product of any primary election. Therefore, in my view, the requirement to conduct a fresh primary election does not apply to the nomination of the vice presidential candidate. Thus, my Lord of the JSC highlighted this point in this one as follows. The fourth respondent was not required to buy any nomination form. He was the second respondent, APC's candidate, at the election into the office of Senator representing Borno Central District. But before the election could hold, he was nominated as the third respondent's associate, who is to occupy the office of vice president. The fourth respondent did not buy a nomination form for the said office, and most importantly, did not contest any primary election in order to emerge as APC's vice president candidate. The petitioner in paragraph 28.2 of this petition had averred and also contended in his final address that there was a gap of about 3 weeks between the period the first respondent expressed his intention to withdraw and his actual withdrawal of purported nomination, thereby validating the nomination of that respondent, because the candidate of that respondent had lapsed and was no longer in the position to constitutionally
You see this? You see this?
There is nothing in the constitution which
Tribunal has strike out suit seeking disqualification of Vice President Shettima. So, like I've said before, it has all been in favor of APC. You see?
Was submitted to the first respondent 90 days before the election as mandated by Section 31 of the Electoral Act 2022. This contention of the petitioner is therefore discountenanced. It is therefore my view that the position of a person as vice president candidate not being subject to primary election, the provision of Section 33 of the Electoral Act 2022 does not apply. On that note, I hereby hold that the petitioner failed to prove the known ground of his petition to the effect that the third and fourth respondents were not qualified to contest the election held on 25th February 2023 for the reason double nomination. Having resolved the sole issue of this petition against the petitioner, this petition held to be devoid of any merit.
What are they doing? What are they doing? Why are they laughing? Oh yeah, now continue now. Stop wasting our time. E be like say Abure don vex comot o. The Labour Party chairman, he don vex comot because of the kind of maybe dem dey alter something make e no like. He don comot there. Continue, I don't have fuel.
will rise for just 15 minutes and come to continue with petition number 3. In fact, I can see Dr. Lily moving up and down. So, as an elderly person, I know what is going on.
So, they are going for a 15 minutes break. So they will come back to start with petition number 3. So far, so good. Disqualification of a candidate on the basis of double nomination is a pre-election matter. The political party cannot impose credibility status on any candidate unless as prescribed.
Oh, my Lord, please. Just needed to know, sir.
Yes.
Thank you very much, my Lord, sir. Thank you, sir.
So like I was saying, a political party cannot impose credibility status on any candidate unless as prescribed by section 62, 131 and 137 of the Constitution. Justice allegedly strike out Shetima's double nomination case. So that one no day again. Shetima is victorious. So when they come back, 15 minutes break, 15, they are going to continue others. Throughout today, now this thing we go talk about, that this election matter, we go to talk.
Well, so far. Well, we can't tell at this time if it's the first part, but first part of the proceedings has just gone underway.
Well, what the justice said was that's the fourth item, so to speak. So there's still the third one, there's the second and the first. But the reason they're taking them all up together is according to the justice. They are consolidated. In other words, they are all related one way or the other. You see that a number of times he would say, look, as we had previously mentioned, it's a pre-election matter. As previously mentioned, it's a pre-election matter. But at least one thing can be said clearly now, that this court has struck out APM's suit against Shetima and Tinubu for lack of merit. For the preliminary objection, the court held that the petitioner, that's APM, ought to have filed the case before the Federal High Court within 14 days from the course of action, from the day of the course of action arose. The court agreed with the respondent that the issue is statute barred, and consequently, the justice who read the lead judgment added that Section 285 sub 14C does not allow members of any political party to challenge the nomination of candidates of another political party, and consequently declared that the petitioner lacks the local standing to institute the petition.
And recall that the PDP did indeed take the matter to court as a pre-election matter, and the Supreme Court held that there was no double nomination. So on this case, the petition, the judge has ruled that the petitioner failed to prove that the third and fourth respondent failed to prove that they were not validly nominated, and on that strength, has been struck out for lacking in merit.
It's a long haul. We're still. This is pretty much as we have been informed. The long haul.
The long haul. Verification.
Yeah.
We could be here for another 2 to 3 hours, so to speak. But in response to one of the council's inquiry just moments ago, Justice Salmoni may have said that it's a contributory judgment. I wonder what's the implication of that. Is it that it's a contributory judgment from all of the other 4 justices, or will there be a dissenting judgment?
Well, I guess that's what we'll wait to see, because, I mean, if you recall what Mr. Quakers told us the other time, as well as Dr. Titoji in Abuja, that look, a lead judgment could take X number of hours. And if you also recall what the justice said to us, this is just the judgment. There are other arguments in it, you have to get it later.
Mm-hmm.
I'm like, okay, so this whole conversation started sometime around 10 o'clock?
9:27 to be precise. I took note of the exact time that the judges walked in. But, you know, just also warn you.
So, let us go and relax a little bit and argue. They will come back. Let us go and relax a little bit and argue. They will come back as soon as they come back from break as well. So far, so good, though. I thank God, yo. I think we should, since they just took a break for 15 minutes, we are still here. We are going to relax and come back. They just took a break for 15 minutes. So let me also use the opportunity to rest as well. We will get our judgment today. Let's go and come back, guys.